Do they normally train their staff to walk people around in circles so they get so frustrated and walk away from the matter?
All right, let me call the case again. This is Amber Manley versus Ashley Furniture. File number is 242120. Amber Manley is here at the courthouse, and Mr. Lauren Kloppenstein is at his office. This was an original claim for $1,669.17 plus court costs. And I found, well, let's back up. The lawsuit was served. Mr. Kloppenstein filed an answer. We had a hearing where we heard a lot. I continued the matter. Find my note page. On January 6th, I continued the matter for 60 days to March 10th at 3 o'clock via Zoom. And you got a notice of that hearing. So I've already found by default that Miss Manley is entitled to this money. She was here on the 6th. She had pieces of furniture with her. Her husband was with her. She was quite aggrieved. I continued the matter to allow you to try to rectify the circumstance. Okay. So at one point, she'd have a bunch of mismatched lawn furniture. So I continued it to March 10th. She came in and she was here on March 10th, and I put her under oath, and the chair that was at issue had been repaired. She had an issue with another piece of furniture, but I said she had to file a separate complaint to deal with that if she wished to. Anyway, I was very disappointed that you weren't here. So you weren't here. The chair that was at issue had been repaired. So I had no choice. Well, I did have a choice, but I entered a judgment of default. She was here and you weren't. She took time off of her day and she came here. I told you on January 6th that the hearing was continued to March 10th. I sent you a notice by mail telling you the hearing was March 10th, and you didn't show up. So after you got this judgment, you filed a motion, or you wrote me a letter dated March 28th. Now, there is no appeal from small claims court. Any decision there is final, but this was a default judgment. So you wrote this letter, which doesn't really amount to a motion to set aside a default, dated March 26th. We got it on March 28th. Dear Judge Middleton, we recently received a judgment against us in case 242120 for Amber Manley. We were unaware the second trial had been scheduled. We did follow through from our first Zoom trial on January 6th and replaced the armless patio chair. Since we did not know about the follow-up date, we ask you to reconsider your judgment, awarding $1,735.42 to Amber Manley. So I'm treating this as a motion to set aside the default. This is small claims court. He just wrote a letter. But your letter is not accurate. I told you on January 6th that the trial was set for March 10th at 3 o'clock in the courtroom. And then we sent you a notice. I checked the file today.
Your Honor, and I apologize for that, but we had replaced that chair for her. That was a contention on it, and we definitely had it replaced for her. And I didn't realize it was another hearing, and I'm not saying you didn't say, I apologize for that, but yeah, I did not realize there was another another hearing, but we did replace that chair for her that she had spoke about during our first hearing.
And I was aware of that, and she acknowledged it.
Yeah, we didn't repair it. We actually replaced it for her.
All right, well, that's fine. But it was set for a hearing and you weren't excused. In order to set aside a default, you have to show there was good cause to set aside the default. Maybe there's good cause because you replaced the chair. But you have to show a legitimate reason for failing to appear. And you said you were unaware there was a hearing, and that's not accurate.
Well,
did.
What I'm saying is that I apologize. I'm not saying that you didn't say that at your hearing, at the first hearing. You very well could have. But all we were thinking that the chair was replaced, and so we thought everything would have been fine.
Well, this wasn't an agreement that you made over the kitchen table with a handshake. It was a court hearing. And Ms. Manley, what's your position?
To be honest, Judge, I think that you were very fair to me in the very first trial. I am out a piece of furniture still. Yes, have I gotten the runaround? And yes, would I like my money back? But I am willing again to receive a new piece of furniture. I brought it in last time. I have pictures of how their repair center tried to repair my furniture and then wanted more money from me. So I want to know if Mr. Kloppenstein knows about the hassle that I have went through with this next piece of furniture. And do they normally train their staff to walk people around in circles so they get so frustrated and walk away from the matter? Because if I would have known, I would have went and did another small claims for this next piece of furniture, because I have a year for warranty work. I just wasn't going to take that piece of furniture and walk it up to the front desk area and demand to speak with a manager that would not come back to the customer service loading dock. I wasn't going to put myself in a position to ruin the outcome of our next court date, for them to say that I went in there and caused a scene and cost them money or whatever the case could be. I just wasn't trying to do that. I thought I was going the right way by coming to court and trying to settle and just get what I paid for and what I'm worth. You know, I work hard every day, just like their staff, and I just want what I deserve.
Well, I heard a lot of testimony about this first chair. Mr. Kloppenstein replaced it. You were unhappy about another piece of furniture and you brought it in here on March 10th. But this case was not about that other piece of furniture.
Can I say something?
Yes.
When I brought in this very whole lawsuit, it was for all the furniture, every single piece in its entirety. That was the whole amount of this furniture. So in my opinion, I did bring in. It might have been one piece out of the whole bunch that was broken, but it's a set.
Your Honor, the only piece that we knew about was the one chair that we had talked about.
Yes.
I mean, I had to
All right,
talk
stop. Only one person can talk at a time. Mr. Kloppenstein, the person you need to apologize is to yourself, because you didn't show up for your court hearing that I told you about in court, and I sent you a notice, and you got a default judgment, and I don't find a legitimate reason for your failing to appear for the hearing. So I guess we're not going to fight about this other piece of furniture that she's still dissatisfied about, but I find the motion to set aside is denied.
Well, Your Honor, can I just explain to you? I apologize.
Let me finish.
Okay.
I understand you dropped the ball. I understand you thought it was done because you gave her the chair back, but it wasn't done. You didn't have my blessing to dismiss this. She was here, she was still upset, and you didn't show up. So I find there may be a legitimate defense, but there was no legitimate reason for failing to appear.
Look, may I speak, Your Honor?
Yes.
And I was out of the country.
Okay.
I'm not saying that's a good reason. I'm just, you asked me for one and because I thought.
Well, that's a different reason that I didn't know. If you're out of the country, I guess you could ask for an adjournment. So the original judgment stands. Denied. I don't have to like it, but I don't find there's a legitimate grounds to set the default aside under the court rule that would apply in a general civil case. So you owe her $1,735.42. A bad deal for all concerned. Nobody's very happy. But the original order stands. The fact that you either didn't know, which isn't accurate, or you were out of the country and you didn't tell us, neither one of those is legitimate. If you'd have told us, we could have adjourned it. All right, you're good to go. That judgment stands and you owe her that amount of money and you have 30 days or she can pursue other collections.
Your Honor, can I ask?
No, I don't want to hear any more about it.
Is she gonna bring the furniture back?
No, you owe her $1,735.42 for your own failure to address this accurately. All right, I don't know whether he'll pay that or not. If he doesn't, you can do a discovery hearing. And like I said, nobody's happy here. You don't have to return the furniture. We'll just leave it at that. You're free to go.
Thank you.
All right, we're still plugging away here.